Good evening, viewers. Welcome to this law lecture series. Today's topic is Doctrine of Menstrua, Part 3rd in English. Very soon you will have the Hindi version of this lecture also. In the preceding lectures, we have learnt this Latin maxim, actus non fecit reum nisi mensit rea. Actus reus and mens rea both must concur to constitute a criminal liability. Actus reus here means act or omission forbidden by criminal law, and mens rea here means guilty state of mind. No criminal liability without mens rea. If there is no mens rea, there is no criminal liability. This is general principle. This is called Doctrine of Menstrua. Doctrine of Menstrua says if there is no guilty mind, there can be no criminal liability. But here we have two exceptions. Mens rea yet no liability. There is mens rea yet no liability. There is mens rea, yet there is no liability. Why? If mens rea is there, there should be liability. Yes, there should be liability. But this is exception. There is mens rea, yet no liability. दुराशय के बावजूद दायित्व नहीं है. And see the second exception. No mens rea, there is no mens rea. So what? You are still liable. In first case, durashya hai, there is mens rea, but no liability. In second case, there is no mens rea, yet liable. So, general principle is that no criminal liability can arise without mens rea. And here are two exceptions. First, there is mens rea, yet no liability. Second, there is no mens rea, yet liability. Now we will be detailing it. First, mens rea yet no liability. Exception number 1. I am entertaining a mens rea. I do possess a mens rea, yet I am not liable. Why? Because my act is a petty case. My act constitutes a petty case. Whatever I have done, that is very small, trifle, petty. I am not saying that I am not having mens rea. I am possessing mens rea. And I have also done an act which is contrary to law. But my act is a petty act. I shall not be held liable. There is mens rea. There is actus reus, but no liability because act is a petty one. So pettiness is a defense. If my act is a petty act, I am not to be held liable criminally, notwithstanding that I am possessing mens rea, notwithstanding that I have done something which is in breach of criminal law. Petty cases, see this maxim, de minimis non curat lex. Law does not take care of trifles. Law does not take care of petty things. De minimis non curat lex. This maxim is based on public policy. and general convenience. It says no one should be geoparadised, no one should be put to inconvenience for petty things. No one should be put to jeopardy. No one should be put to inconvenience for petty things. De minimis non curat lex. Law does not take care of trifles, even if there is menstria, even if there is actus reus. But if the act done is a petty one, no criminal liability. Second exception is this justified act. First हो गया petty cases. The first one is petty cases, and second one is justified acts. So now justified acts. Suppose I attack you, or I attack your property, then you will repel with force. You will resort to private violence. You will defend your body. You will defend your property. Here, you have a menstria. You warned me, caution, don't move forward or I will shoot you. Your menstria is reflected. But whatever you have done, though it is with menstria, but at the same time, act done by you is fully justified. You have suffered an attack. And if a person suffers an attack, then he has a legal right to defend himself. So cases of right of private defense, cases of right of private defense under the IPC constitute justified acts. Here there is menstria, but at the same time there is justification. In the consequence, no criminal liability will result. Act done in obedience of law or in discharge of a legal duty. Suppose I am a police officer and I chase a criminal. I warned him, I asked him to stop, but he is running away. He is a murderer. In order to effect his arrest, which is my legal obligation, which is my legal duty, statutory duty as a police officer, I shot a fire on him. Here I am having menstria. I am entertaining a menstria, but at the same time, whatever I am doing is, I am bound by law to do that. So here again my act is justified. Menstria with justification, no criminal liability. Menstria when the act is petty one, no criminal liability. Pettiness is a defense under section 95 IPC, and right of private defense and acts done in obedience of law or in discharge of statutory duty, legal duty is no offense. In both these cases, the accused did possess menstria, but he will not be liable criminally because there is either pettiness or there is justification for the act. This first one we have discussed, menstria yet no criminal liability. Now let us see the second exception. No menstria, there is no menstria, and yet liability. No menstria, yet liability. This is called doctrine of menstria exception. So now we are discussing exception to doctrine of menstria. There is no menstria, still I am liable. When in Shiraz versus D. Rudgen, it's a leading case. Shiraz versus D. Rudgen, 1895, decided by Justice Wright. In this case, in Shiraz versus D. Rudgen, 1895, Justice Wright pointed out certain exceptions to doctrine of menstria. In all these cases, In all these cases, I do not possess menstruia, still I am liable. Liability without menstruia. Yes. So what are those cases? See, first, cases of strict liability. Cases of strict liability. Strict liability means bigamy, public nuisance, matters relating to public morality, health and safety, matters relating to drugs, edibles and social welfare, and where it is difficult to prove menstruia. Here there is strict liability. So first exception is strict liability. And to explain the strict liability as an exception to doctrine of menstruia, you have to suggest 5 points. First, offense of bigamy. Here there is no menstruia, still person will be liable. Offense of public nuisance. Here there is no menstruia, still person will be liable. Matters relating to public morality, health and safety, matters relating to drugs, edibles and social welfare. In all these cases, the accused is not entertaining any menstruia, yet he will be liable because the liability is strict. Sometimes it is very difficult to prove menstruia. In such cases also, person shall be held liable without menstruia. Now, second exception, ignorance of law. No accused can say that I was not knowing the law, I was ignorant of law, so I committed breach. Ignorance of law is no defense. Even if you are having no menstruia, but you have breached the law, and now you are saying that you were ignorant about law, you were not knowing about law. Ignorance of law is no defense. And if you have committed some act against the law, you shall be liable. These are the cases where there is no menstruia. The real cause is ignorance, but ignorance is no defense. A presumption is raised that everybody knows the law of the land. A presumption is raised that everybody knows the law of the land. So ignorance of law is no defense. Maybe that you are not entertaining menstruia, but if you have breached the law, you will be punishable as an exception. Preventive purpose is the next exception. 399 IPC. 399 IPC, very important section. Making preparation to commit dacoity. Making preparation to commit dacoity. And 402 is also important. Assembling for purpose of committing dacoity. Making preparation to commit dacoity. 399. Assembling or collecting for committing dacoity. 402 IPC. Here there is no menstruia. In both the cases, the accused is not entertaining any menstruia, but he shall be punishable. Here the purpose is preventive. So sometimes when there is a preventive purpose, menstruia is ignored. Even if there is no menstruia, the purpose being preventive, I shall be held liable. And two important cases are sections are 402 IPC and 399 IPC. Next, public interest. Public interest. There may be certain acts in violation of revenue law. Suppose a person is not paying income tax. Suppose a person is not paying goods and services tax. Suppose a person is not paying land revenue. Here there is breach of revenue law. It is purely a simple civil matter. But in public interest, it is punishable. So sometimes a civil matter is punishable in the larger public interest. Offences against revenue law are without menstruia, yet the person committing offences under the revenue law is punishable. This is in the larger public interest. Last, enforcement of civil rights. Enforcement of civil rights. See, the SC and ST Prevention of Atrocities Act. The SC and ST Prevention of Atrocities Act. I may be punished under this act, but I am not entertaining any menstruation. But still I am punishable. Why? Why? So that person belonging to SC or ST community may preserve his civil rights. This is a way of, this is a summary mode of enforcement of civil rights of persons belonging to SC or ST community. Here there is no mens rea, yet I am punishable under this act. This is summary mode of enforcement of civil rights. Here the acts are punishable only in form. Only in form. So these are the cases of exception. Doctrine of mens rea. Exception. Siraz versus D. Rudgen. Justice Wright. He has pointed out all these exceptions. Thank you very much.